interesting response from all of you. The question, one of the questions is not only in the area of civil rights, but just in general. Is Justice Rehnquist open-minded?
I've seen no evidence of any open-mindedness whatever. I think anyone reading the constitutional opinions would find that he has followed what he felt was okay in '52 segregation, that he has followed what he thought was wrong in the later periods when he opposed all civil rights legislation. He is so consistent that on his anti-civil rights positions, on his what I call statist positions, on his belief that the state is always right and the individual is always wrong, he is so consistent on that that I don't see how anyone could call him open-minded.
Any comments or reflections from the other witnesses on that?
Senator, certainly, as the last 4 years, I have chaired in the state of Maryland the Senate Executive Nominations Committee, which would be the comparable committee to this committee in my own home state of Maryland. And as chair of that committee, we've had appear before us judicial appointees of the governor. One of the things that we have been able to see from that position is whether or not judicial appointees are open-minded and whether or not they are fair and impartial. And when they fail that test, certainly that is a reason for rejection. Not so much philosophy, but whether they are fair and impartial and willing to put aside their own personal views. And I don't see that in Justice Rehnquist. Even if there was a modicum of it, I don't think many of us would be here.
If I may just say that very briefly, that reading the record convinces me that when we talk about the cases where, and I just want to repeat this one thing, that I have seen Southern politicians change, and that's important. I am not holding against this man all that he said 20 years ago. I am dealing with the fact that I have not seen the change, and I have seen it up and down the South, and I travel, and senators and all of these people, I've seen a genuine change. And if they haven't changed, at least they give lip service to it. Mr. Rehnquist, in my judgment, does not even give lip service to it. And I don't think that the reading of this record would show that he's open-minded, because where he has agreed with the changes in the civil rights situation, it seems to me it's been grudgingly and of necessity. And wherever he has an opportunity to knock it down, the Bob Jones case on some specious reasons about statutory authority versus authority given to the IRS, and that's not a really good reason. But where he has found anything to hang his hat on that can keep the status quo from moving, from keep progress from happening, he has done it in school cases, in employment cases, in that case involving the Moose Lodge, the private property. I see a consistent strain of what he said in '64, that the right of the restaurant owner is more important than the right of the individual to be a citizen. I see it in the Moose case. I see it in what Joe Rao refers to as the statism above the individual.
Senator Simon, if I may speak as the one representative here right now from the women's rights community, I think that one can say on reading all the women's rights decisions that they are extremely result-oriented, almost without exception, that they are straining in many cases at the bit to reach the result that he wants to reach, and there doesn't seem to be very much evidence of open-mindedness there.
Well, Senator Simon, I would make two comments to that. One, it would be extremely difficult to come up with an example of Mr. Rehnquist having voted with the majority in upholding the civil rights, civil liberties claim of a black person before the court in a closely contested case. That's going to be extremely difficult to find. And in these cases that are 4-4 cases, if I had a client that go before the Supreme Court and it depended on the Chief Justice, I would have to tell that black civil rights plaintiff that more than likely that case would be lost. The Legal Defense Fund litigates in the Supreme Court. I mean, we had 23 cases there this term in some form or another. And when you go there and you argue, and Mr. Justice Rehnquist, as an associate justice, sitting over to your right, to the second justice in, is one thing. And when he asks you a question, it's the question of, when he asks you a question, you just know in a closer contested case, his mind is made up. And so you answer the question in such a way as to educate and hopefully illuminate the other justices on the court. I mean, now, to move Mr. Rehnquist from that position to the Chief Justice, so when you come there and that is, it's going to affect practitioners, I mean, and the impact that it's going to have in terms of civil rights lawyers and civil rights clients across the country, and you are right on target. That question of perception and symbolism is paramount and critically important on this issue.
I thank you, and I thank you, Mr. Chairman. I hope my time is not charged against Senator Metzenbaum here.
Mr. Chairman.
Distinguished Senator from Ohio.
Chairman, Mr. Hooks, in the statement your organization issued